and I'm going to open the webinar to everyone in just a second, okay?
Hi, everyone. Thank you for being here. My name is Neda Bellucci. I'm the Executive Director of PAAIA. And in today's Learning the Landscape webinar, we are joined by Rojin Mustafar Mer, Vice President, if I remember correctly, of the Iranian American Bar Association National, Paris Etemadi Scott at PARS Equality. I'm so sorry, I think she's the legal director. I cannot remember directly off the top of my mind. She'll correct me momentarily. And Ali Rahnama, who is the acting executive director of the Iranian American Legal Defense Fund. Thank you, everyone, for joining us today and being here. I want to be brief on those introductions so that we can start by acknowledging that many of you may be carrying a lot of anxiety, uncertainty, and confusion. And that's why we're doing this webinar. For Iranian students in particular in the United States right now, it can really feel like the rules are shifting under your feet precisely because they are. And sometimes it's not really clear what the rules are, and that is just a fact. And part of this webinar and the main goal of this webinar is to try to elucidate what's possible in terms of what's not shifting. And so, as many of you know, international students have always had to navigate immigration law. But what's different today is that you're navigating this law and different types of law in the middle of tense geopolitical moments and changing enforcement priorities and a level of discretion that is quite unpredictable, and that is quite unprecedented. And that combination, we think, has created, and rightfully so, a lot of fear and anxiety, not just about the paperwork and the legal documentation you need to have, but about travel, future plans, and everyday life. So today, our goal is to not to overwhelm you, but try to clarify in general strokes what's changed, what's not changed, and where the real risks are emerging. We're going to try and focus on practical, immediate questions that come up constantly right now. For example, your status, what it actually means to be in status. Speech and social media may be part of this, what to be mindful of. Travel, especially why international travel has become significantly riskier, even if you are in status. And long-term planning, what it means to be and try to get OPT, STEM OPT, and the change of status strategies. We also want you to leave with something a little bit more important than just information, but possibly a framework. This is a landscape that's stressful, and understanding it helps make decisions from a place of strategy rather than panic. And so we'll be trying to briefly explain the December 2nd USCIS policy memo, because it's one of the key developments shaping what many of you are experiencing right now, particularly around adjudications, delays, and why certain cases are being paused even when people are fully eligible. And furthermore, we're also trying to, as part of this clarification, let you know that you're not alone, and you're also not imagining the pressure. This is real, it's significant, and it's changing your lives. And so we're going to try and walk through it together, carefully, clearly, and with a focus on what you can control. In terms of PAAIA, we are, as most of you know, not a legal organization, but ways that we are moving to work with students is we have an application process for that is repetitive of most of your immigration and academic paperwork, so that the most exemplary, not to say that all of you are not exemplary, but the most exemplary who are facing possible deportation actions may get, in conjunction with members of Congress, special attention. And so in that way, the relationships that PAAIA has in Washington, D.C. and on Capitol Hill are ways that we are moving to help students who are feeling threatened and are in a position and understand that they may lose their status. So that is one of the ways that, as an organization, PAAIA is moving forward to try and help beyond doing education and advocating for students. With that, I want to open sort of the outline that I've given to Paris and let you all know that we are, again, going to try to briefly cover the subjects that I mentioned, but we've left within this hour a significant amount of time for questions and answers. We think that the best way that we might be able to help you is to open the floor to your questions. So if you have a question during one of the topics, please go ahead and put your question into the chat box, again, because we have tried to leave a significant amount of time to get to those. And with that, Paris, please, the floor is yours.
Thank you, Neda, and it's great to be among my amazing co-panelists and to briefly present the latest policy updates that are affecting not only the Iranian community, but also all the other nationalities that are on the travel ban list and the expanded travel ban list. And in fact, almost practically everyone who's filed an asylum application currently in the United States. So I don't want to take too much time with introduction. I just want to, before I share my screen, I just want to mention that the anxiety is twofold. One is the media coverage on ICE arrests and detentions, and that's something that we're not going to focus on in particular today. We're going to focus on the policy updates and how that affects the pause on applications. Of course, you're more than welcome to ask questions about ICE detentions and arrests, but the focus really is to let you know what the updates are coming out of the USCIS agency, and then how that affects folks who are on F1 status or F1 OPT or F1 changes status to H1B and so on and so forth. So I'm going to start by giving you a quick update on the policy changes that have come out of USCIS in the wake of the National Guard shootings that happened on the November 26, 2025, and how USCIS immediately announced changes to its adjudication based on the applications that are filed inside the United States. Now we're talking about applications that are filed by folks who are inside the United States and filing to get benefits. Now, whether that's filing for citizenship to become a citizen, filing for a change of status, let's say from F1 to H1B, filing for a green card, let's say you're an asylee and you're filing for your green card. So these new immigration restrictions that we're going to talk about today are mainly concerning applications filed by folks who are inside the United States and trying to change their status or obtain or adjust their status and obtain a green card, let's say, or citizenship. So as I mentioned, when the Afghan asylee shot and killed 2 National Guards on the 26th of November of last year, USCIS issued a policy memo on December 2nd of 2025 announcing holds on certain immigration applications, and their justification was national security and public safety concerns. They also immediately announced that all visas for Afghan nationals are placed on hold. Of course, we know that there was a travel ban already in place affecting Afghans, Iranians, and other nationalities. And so this one just basically said, regardless of the exceptions of the travel ban, no visas issued to Afghans. And then subsequent to this, an executive memo came out end of December, 16th of December, and added additional countries on the travel ban list. But we're not going to go over the travel ban right now. We're focusing on the first bullet point, which is the USCIS policy memo affecting applications filed by folks who are inside the United States. So there are 3 separate policy updates that came out of the December 2nd, 2025 memo. The first is a blanket hold on all asylum applications filed that have not been adjudicated, and regardless of the nationality of the person who's filed the asylum application. So you could be Mexican, or you could be Iranian, or you could be any other nationality who has filed an asylum application and are waiting for your asylum adjudication, that final decision will not be issued. The decisions on all asylum applications have been placed on hold. And it's pending a comprehensive review, background check, and so on and so forth. What USCIS has subsequently clarified by a January 1st, 2026 memo is that they will still review the cases. It's not like the hold doesn't mean that they're not going to look at the case. They're actually going to look at the case, but they're not going to make a final decision on the case. So they may even issue a request for evidence. They may even issue a notice of intent to deny your case, but they will not issue a final decision on the case. That the decision on these cases have been placed on hold. So this affects all those. We do have some F1 students who have filed asylum in parallel to their F1 status. They've kept their F1 status. They're attending school. And so they're invalid F1 status, but they have filed an I-589 asylum application on the side as a parallel path. And those applications are now placed on hold. So the second policy update is a hold on all applications from countries, for nationals of countries that are on the travel ban list. The December policy memo, obviously by then there were only 19 countries on the travel ban list, so that affected 19 countries. But subsequently, 20 more countries were added to the travel ban. So those 39 countries are now whose applicants are inside the United States. So they are from those 39 countries and they're inside the United States and they have filed applications. All of their applications are placed on hold. Again, the January 1st, 2026 memo clarified that the only exception seems to be a green card renewal application, I-90. So if you file an I-90 to renew your green card, that doesn't apply here on the hold issue. But other than that, applications are going to be placed on hold. The other thing that we found out recently from this January memo is that it doesn't matter if you are, let's say, a French passport holder, but the fact that you're born in Iran, you are subject to this hold policy. And that is really concerning. So they've clarified that this applies to folks who are born in one of those 39 travel ban countries or are citizens of those 39 travel ban countries. So that's really concerning. And that, you can imagine, affects so many people. So you get 39 countries. Many of those countries, people from those countries have gone to a subsequent country and gotten a nationality from a subsequent country. Let's say some of the African nations have a French passport, but it affects them as well. So that's really concerning. And that's the hold on all applications. Just give you a scenario here. We've had Iranian green card holders that we've represented. We went with them to their citizenship interview. They got approved and they got their oath ceremony scheduled. All of our oath ceremonies for our Iranian applicants have been canceled for the time being. And there is no rescheduling. We haven't received any reschedules. So that's the effect of this hold. That's just one example of how this hold is playing out. And then finally, this is a very concerning policy update. It's the re-review, again, double review. I don't know, two positives become a negative, I don't know, but of the approved benefits of folks that are, again, concerning, not only hold passports or nationals of those 39 travel ban countries, but were born in those countries. Let's say Iranians, we have a lot of Iranian Canadians. This affects them as well. So it's going to be re-reviewed, and so what is going to be re-reviewed? All the approved benefits from individuals from those countries who are either born in those countries or have a passport in those countries who entered the United States on or after January 20th, 2021. Now, another concerning update in the January memo is that they've changed that wording. They said it's not folks who entered the United States after that, it's for benefits that were approved after January 20th, 2021. That is extremely concerning. That means that somebody could have been here for 40 years. Maybe they were a green card holder for 40 years, and then they applied for their naturalization, and they got their naturalization was approved January 25th, 2021. That potentially that approved naturalization application is potentially subject to or not potentially is subject to re-review. So this is what we're dealing with. So it's these three-pronged policies, and that's why there are a lot of questions coming from students in particular, or anybody else who's pending status, who's going to stop share here. Sorry, who is either an F1 student, F1 OPT, pending OPT, or maybe in OPT status, and there's a job offer and the employer's filing a petition for them. This affects everyone. But I will now let Brugine follow on as to how this may apply to folks who are on this call, who are students who are concerned about their status, and what is sort of the advice going forward.
Thanks so much, Paris. It's a pleasure to be here today. What I'm going to go over is sort of being an F1 status and what that means. And I think that it's important to sort of go back to the basics of what it means to be in status and, to kind of alleviate some of those concerns. There might be people on this call who are abroad, who have applied for F1, who might have questions. So I want to start off very quickly to address those, any concerns there. So persons who are abroad who have been, they've been accepted into a program. Maybe you had an interview for an F1 visa before the June proclamation that instituted the travel ban. Maybe it was before the Trump administration, you had that interview and you've been in administrative processing for a year. Unfortunately, it does not matter when you were accepted into a program. It doesn't matter when you had your interview or how long your administrative processing has been taking. They are not issuing visas from anyone in Iran right now pursuant to the June proclamation. And we didn't really talk about the June proclamation and the travel ban very much, but just wanted to note very quickly, the reason I bring this up is, and we'll talk about class action suits, is we had a travel ban under the first Trump administration. You saw a lot of those class action suits where they were challenging the legality. This proclamation was written a lot differently. There aren't any exceptions or waiver provisions for humanitarian or hardship waivers. It's basically full ban on Iranian nationals applying for any visas to enter the US. Unless you're in the national interest, and they have very specific definitions of what national interest is. It's basically being helpful to very specific agencies like the Department of Justice, for example. So that makes it very, very narrow on who's, being issued a visa. And I mention this because in practice, I can say from an IABA and also from an immigration attorney perspective, I haven't seen anyone be granted one of these. I'm not sure if anyone else on this call has as of today, but it's just to sort of give the scope of that. So that's for persons who are abroad who have not gotten their F1 visa. So for everyone else, so if you're here in the States and you're in F1, what does that mean with all these things that are happening? You're in status. So if you've entered in F1, you're in your program, you're maintaining your course load, you're, meeting all the requirements for your program, you're in status. None of these proclamations or policies are impacting your status here in the States at this time. One thing to just want to mention is when you entered the United States last, as you may know, you're generated something called an I-94 arrival departure record. It says when you last entered, it says what your status is. It says the expiration, like how long you're admitted until. F1 students are admitted to, it says DS, that's duration of status. And I mention this because it means you're admitted for the duration of your program term. So you don't actually have a finite expiration at this time on your program, your time here in the US. And that's extremely important for purposes of, unlawful presence concerns or overstays, anything like that. It's kind of a cushion for you in some way in terms of being able to be here. So if your program takes longer, or it's shorter, or you change anything, you're in F1 status so long as you're meeting your requirements for your school to remain in F1 status. With regard to international travel, Netta, start off by saying like travel is a concern. Right now, no one should be traveling. If you're an F1, it doesn't matter, you're not going to get a visa. I just started off by saying that there's a travel ban. They're not giving visas to persons from Iran. If your visa is expired, it's single entry, you're not going to be able to get back in on that F1 visa. And as Paris mentioned, you could be someone who's a dual national. So you could be someone who has the Canadian passport, but you might, be born in Iran. This is personally, like as an immigration attorney, I hesitate recommending travel at this time. While you might have the ability to enter for various reasons, whether you're visa exempt as a Canadian national, or if you're coming from another country and you have a valid visa, you are going to be subject to higher scrutiny upon entry right now. And we have seen, and so what does that mean? They can, their secondary inspection is pretty standard as what we're seeing on the ground right now. They're able to check your social media, and I'll talk about that in just a second and share some resources on that. But the safest thing to do is to stay put in the States. Travel domestically. You can go to Hawaii, you can go anywhere in, the 50 states, but stay put in terms of travel. And about 7, 8 months ago, we saw a lot of news about, deportation concerns and, removal concerns for F1 students. There was a roundup that was happening. A lot of sort of very stringent background checks were happening, and a lot of them weren't correct. There were a couple lawsuits that happened that challenged that, and everything sort of dissipated. I really want to mention that while there is a lot of media coverage on deportation and detention concerns, you being here as an Iranian national, maintaining your F1 status, unless you have you're not maintaining your, full course load, or, abiding by the requirements of your F1, or let's say that you have a run-in with, law enforcement in some capacity. Unless you have any of those issues, or you've misrepresented something on your DS-16, you neglected to mention something, for example, on its face, there's no reason for you to be worried about a deportation case. And that's a very general statement, but I would just say that you really want to, feel comfortable in the fact that if you're an F1 student and you have a clean record, just keep maintaining your F1 status and go to school, that sort of thing. And with regard to if you do have a run-in with law enforcement, I think it's the most important thing you do is you talk to an attorney. In just a few minutes, I'll share some resources that the IABA has prepared over the last year that, know your rights with interactions with ICE and law enforcement, as well as detention. But, if you have anything like that in your background, or you've done that, please talk to an attorney just to see what, what that means, what the implications are for peace of mind, or what you might need to do for your status. Now, some of you might be approaching graduation soon, or you've just graduated, or you might be in your first year of post-completion OPT. And so you're looking to apply for either post-completion OPT, or you're looking to potentially apply for your STEM extension soon. As Paris went over, as of January 1st, all adjudication of immigration benefits from persons from travel ban countries, they've all been held. So that means that they're not going to adjudicate OPT or STEM OPT I-765 applications. However, you can still file these applications, and you should still file these applications. As you know, as an F1 student, once your program's complete, if you qualify for OPT, you have a certain amount of time you can file for OPT that allows you to stay in the States, and you're allowed to stay here while that application is pending. Okay, I'm going to repeat that again. You're allowed to stay here while that application is pending, so long as it's timely filed. Okay, so it's important that you file, because that's your preservation of status. That allows you to remain here in the States. And the caveat is they're not going to adjudicate as of today. We have this pause, they're not going to adjudicate the application. And we can talk, we'll talk about what that means for job offers and things like that. But it allows you to stay here. And you don't have to be worried about, am I holding status? Am I not holding status? For STEM OPT applicants, once as long as you file before your post-completion OPT ends, you get an automatic 180-day extension of work authorization by virtue of a timely filed STEM OPT application. Okay, so if you expire today, January 7th, so long as it's been received, that application today, you get 180 days automatic extension of work authorization while you're waiting for that EAD extension to be adjudicated. Now, practically speaking, the unfortunate reality is for post-completion, you're not allowed to work until that EAD is in your hand. So that is the unfortunate reality. And unfortunately, you can't force employers to keep offers while you're waiting for this to be adjudicated. So these are some of the practical realities of what this means. But for status purposes, if you are approaching the end of your program and you're hearing, everything's paused, that doesn't mean don't apply. Please apply because that allows you to stay here in the States. Staying with your STEM OPT, please apply. You get to stay here so long as that application is pending. Okay. For change of status, so some of you might be working already, or you might have an employer that's looking to, for example, enter you into the H-1B lottery this March. There's some changes happening, but the biggest one that you might have heard about in September was there's this $100,000 fee that's being tagged on to these filings. That doesn't apply to people who are in the states that are being entered in the lottery. So I just want to repeat again, if you're here in the states and then employer's putting you in the lottery and you're doing a change of status filing, that 100K doesn't apply to you. That's for persons entering the US. That's one. But the unfortunate reality is because of this memo that was that took effect on January 1st, they're not adjudicating these cases at this time. So practically speaking, the lottery is happening in March. There has not been a clarification on, how that's practically works. A lottery is not exactly an application for a benefit, but it is a lottery. So we have to see, you're picked. They're going to say you've been picked. Do you get to file? That's what we're assuming will be happening. IABA is monitoring sort of the guidance every year up to 30 days prior to the H-1B registration window. The USCIS gives an overview of the new year and what to expect. So we're hoping for that information by February. But that means you can be entered in the lottery. And assuming, they'll do the selection for travel ban country born and passport holders, you'll be able to have an H-1B petition filed on your behalf. But as of today, they're not going to adjudicate it. But all of those steps can be taken. Again, an unfortunate reality is you can't force employers to keep those offers, throughout this process. And there's some questions that have come up, at least for, IABA and also myself personally as an immigration attorney is, are any of these sort of harms a basis for a lawsuit? Can we sue that, I'm going to lose my job offer, or, this is hurting me because I am losing my ability to work. I qualify for work authorization. I qualify for this H-1B because I have this degree. It's not just H-1B. So this means if you are applying for O-1, if you're applying for a TN as a Canadian or Mexican national, all of those things, if you're stateside. Unfortunately, a lot of these are employment law issues with regard to the offers, and all of these memos, I think it's really important to note is all of these have been put into place under the guise of national security. So 212F. And, national security concerns trump any of those concerns. And I think that's the big difference. And I will talk about the class actions in just a moment. I just want to go over practical considerations as an F1 student. Always have your immigration documents with you. Copy of your I-20, your passport, and if you have an EAD, have that with you as well, okay? Wherever you're traveling, in the States, wherever you're going. As you may know, you've seen a lot about social media presence as well. They have the right to look at your social media. A lot of this has to do with visa issuance and Department of State, but expanded ever more into stateside adjudications as well. So I hate to advise people to, restrict their views, whatever they might be, but something to be very aware of is your social media presence, Instagram, LinkedIn, anything that you're doing, make sure that you're very aware of what you're putting out there on the internet. They have a right to look at it. Um, and then finally, for dual nationals, I just want to mention once more, yes, you have another passport you can enter on, but be ready for major scrutiny at ports of entry and any consular appointments as well. I want to pause there before I go into a really quick overview on class action suits. My panelists, if you have anything else that you want to, touch on in terms of F1 best practices.
Yeah, I just wanted to clarify exactly what Regine said about the petitions filed by employers. The first policy memo issued on December 2nd was vague. It wasn't clear as to the petitions filed by U.S. persons, companies, and whether those are going to be placed on pause, because it just talked about foreign nationals from those countries, but the subsequent update of the policy memo clearly stated that applications filed for or by and on behalf of for these foreign nationals are affected. So that means that if you're a U.S. citizen and you're filing an I-130 for your Iranian spouse, that's going to be affected, because initially we didn't know whether that's going to be affected. And also now we know that I-140s filed by companies for individuals, those are from Iran, those are affected as well.
And I just want to give two practical examples. I've been talking, pretty abstractly about all of this. We filed an H-1B before all of this in October at our firm for a person from Burma, another country on the travel ban. And we got an RFE before the National Guard incident that started asking questions about proving up their positive factors against their negative country factors from being from a travel ban country. And it was very alarming. And then a couple days later, of course, on November 27th, there was this policy memo that came out saying that USCIS can consider negative country factors, basically being listed on a travel ban list against someone's immigration benefit filing. And then the week after, the December 2nd policy came out that was going to pause the adjudication of any of these benefits. So this person, we're going to prepare the RFE response for them, but they're not going to have this case approved anytime soon. One other example, the day after the December 2nd memo was issued, I had an Iranian national I went to a green card interview with, and the officer was very candid because they were leaving this office, and they basically closed the door and said, I would be approving this case, our office would be approving this case by Friday, and you would have been notified. However, because of the memo yesterday, I'm not allowed to. And so I say this just to sort of confirm what Paris was explaining, which is they will get the case, they will do interviews, they will review, but they cannot issue a decision. And that's what we're also seeing as well. So a question that I'm sure all of you have is where's the actions? Where are the class action lawsuits? What are we doing as an organization like IABA or anyone else on this call? And I just want to highlight some of the differences from the first Trump administration, what we saw then versus now. And we're in very different circumstances. Under what we say Trump 1.0, lawsuits were filed because the way that a lot of these proclamations and orders were written violated existing laws on their face. There were bases for these challenges. The new bans and policies are very different. And practically speaking, they've had 4 years to work on drafting them. And they're substantively, in terms of implementation, not the same. The basis of most of these actions is a section of the law, INA 12F, which has to do with national security concerns. And it's extremely hard to challenge based on that. So, for example, with regard to the June proclamation for persons who are abroad waiting for those, visas, practically speaking, on behalf of IABA, I can say that we're working with our coalition partners, including those who are on the call, to sort of watch what we can do and see how the proclamation is being implemented. The best thing we can do right now is basically see if they're adhering to what the parameters are for these proclamations. And they're supposed to give an update every 180 days on what's going on and whether they're updates. So just to give an example, for the updated travel ban that was just put into place, they removed Turkmenistan, for example, and they added some more countries. So that's their version of an update, right? But we're also tracking, how are they applying this to different countries? Is there a place where we can challenge on that face? So it's a very different circumstance than, we're looking at this and this is violating all these different, maybe Administrative Procedure Act, laws or anything like that. And one really big difference with the travel ban is the humanitarian waivers and exceptions were removed in the new bans. Exceptions and waivers are only given to persons in the national interest who are being helpful to certain agencies. And because they're so narrow, we're not seeing those implemented. And one big change to the proclamation that I just want to call out that just came out is they removed exceptions for immediate relatives. So just to take a step back, in June when the travel ban happened, there was a list of exceptions. It included that if someone is filing for an immediate relative, that they can they would be able to proceed with that filing. This is separate from the pause on all the adjudication, all the processing of immigration benefits. It was, yes, you can file. We're going to look at those applications and filings. They removed that. And so now those filings are not going to be considered either at this time. Other class, you're seeing class actions. You're seeing a lot of talk about class actions. For example, the H-1B 100K issue that I mentioned in the beginning, there was a huge blow to one of the class actions right before the holidays. Basically, a judge ruled in favor of the Trump administration. So the reason I highlight this is it's really not looking great in terms of very quickly moving forward on some of these issues. There's a lot of sort of data intake that needs to be done because on their face, these laws are really not violating. They're not found to be violating any laws on the books. And with that, I'm just going to turn it over really quick. Oh, please go ahead.
Yeah, along the lines of the requirements and watching, I did want to add that we are working on including a reporting requirement, so a strengthened reporting requirement as part of legislation because those reports are not coming forward. So in the existing and the 2026 legislation that will be happening, PAAIA has moved to actually insert a provision on the reporting requirements. And so that looks like it may, at least on the Democratic side, get included in drafts that are moving through the minority. And so that will be part of, and the reporting requirements would help any, while it's not helpful maybe exactly at this moment, future cases, because the reporting requirements do help any lawsuits, usually.
And, there's a few more floating out there, but a lot of this is, what we're anticipating is they're going to say that they're cannot impose a limit on the presidential authority. That's sort of what we're expecting. And so with regard to the December 2nd policy that was, on pause, impact litigation, which is a group of attorneys, I know they just closed their class call on Monday. And I think that they're likely focusing on the indefinite length of the pause, which is just to show how narrow, the legal challenges can be. It's a very specific issue versus all the things that Paris just mentioned that's in that memo. So we're monitoring that as well. And with that, I'll turn it over to Ali to go over, what Iranian American organizations are doing and other potential solutions.
Well, thank you, Regine and Paris and PAAIA for putting this together. The explanations were expansive, and I don't know how much I can add to that. But one of the things that we're trying to do here is we're expecting a lot of folks have reached out, a big group of students have reached out, expecting the Iranian American community to pick up the cause and mantle and help. And the truth of the matter is that we have to understand that some of these solutions that we tried during the first travel ban might not be exactly available to us. The way that the lawsuits were available to us the first time, both on based on the way that those travel bans were written, and also the Supreme Court that we dealt with at the time, there were more hopes into change coming through the legal system. This time, the lawyers have to be way more considerate of what they're dealing with. And one of the reasons that they have to be more considerate is because they might be making what we call bad laws, bad precedent. And I understand that a lot of lawyers at the moment have become very active and become very creative in the ways that they're going to follow up on these cases. But I want you, as students, to do your homework before joining these cases and understand the legal theories behind each one of these cases that are being offered, if that's possible, by talking to the lawyers you're going to be representing you, and making sure that those cases have enough chances of winning. Now, Rajan mentioned this before. Filing a lawsuit might be the only way for some of the people who are running out of status to be able to adjudicate or stay, because the other side of the issue is that you're not allowed to work. And the financial constraint is going to push a lot of people out. But at the same time, it's important for us to also band together as students, and it's important that these lawsuits are filed in the sense that they're really going to effectuate change, not just because we want to be active lawyers and trying to represent other students. Now, with that on mind, here's what has come to our attention. A big group of students have reached out to us, representing a bigger number in thousands. And one of the things that I'm going to suggest is reach out to us. We want to make sure that all of these student leaders are banded together. They are talking from the same voice, but also the information disseminated to each one of these groups are disseminated among all the students who are part of this. So please reach out.
You went on mute, Ali.
That was the most important part of my speech, and it was just on mute. I don't know how far back he went on mute. But yes, reach out to us. We want to make sure that all the students who are concerned are going to be talking to each other, getting the information from the sources they could trust. On the other side, one of the things that we're thinking about at the Iranian American Legal Defense Fund is whether the community would be able to file lawsuits on behalf of the students. This is we're speaking about it. We don't know if it is still the right time to do so, because if we do file a lawsuit, we want to make sure that it has a good chance of winning. And that's something that we're talking with other partners, such as Roger, Paris, and others on this call, to make sure that we get it right. But at this moment, we're not filing. And if that was told before to people, I just want to make sure that you guys know that Iran American Legal Defense Fund is not moving forward with the case right now. And that's it. Where I want to make sure that we have enough time for questions as well.
And with that, does anyone have I mean, we've left a good amount of time. Our hope is to answer questions. So I think we've got at least a first one from someone really, I think it's more of a statement as opposed to a question. There's a question at the bottom. In regards to legal fees and 30-minute consultations that may be needed, is it feasible to request that from organizations? So I will leave that to the individual organizations to answer that, because while PAAIA is taking on applications for advocacy and congressional help, we are not a legal organization, so these questions are more for the legal organizations.
So I'm the nonprofit person here. Rujin has her private practice, and perhaps Ali could also provide this info from IALDF's perspective. But we do provide free legal consultation if the person is low income or no income. And so if you contact PARS Equality Center and request a legal consultation and mention that you are unemployed or low income based on the income level for your household size, then we will be able to provide free legal consultation. That's one part. In terms of fees for RFEs, lawsuits, again, that's a different story, but RFE, so if we have taken on a case, the case we take on, the case is either free of charge to the low income individual or low fee, and RFEs are part of the case. So if we file the case, we take care of the RFE without an additional cost.
I want to give a little background on IABA in terms of where we fit with our coalition partners. So we're a fully volunteer organization, and we really focus on education and sort of the working with the community of attorneys. So we don't have the infrastructure to provide legal services. So that's where we work with, our coalition partners like PARS and IALDF where depending on, what their requirements are and what cases they work on, those are our nonprofit partners, but we do on our website do have an attorney search that we just launched last year. It's hopefully going to be way more robust in the next couple of months. We just had our elections and going into the new year, but we do have a list of members who do provide their information and their services on the website as well. And then just personally speaking, I am an immigration attorney, and so I do primarily business immigration and a little bit of family, but I work with students constantly. If you reach out to me, I am happy to work with students on free consultations to do this. That's part of what I love doing, is to give back. So that's on the personal level.
I think the question, as I understood it, has two sides to it. One is whether our organization would be able to provide direct representation or consultation. We do not provide direct consultation or representation at the Iran American Legal Defense Fund. Our work is to provide information. And if we're going to court, it's going to be on impact litigation type of cases, which would affect more people. In terms of providing legal consultation fees, I'm not sure if that meant that whether our organization would cover our own fees or whether you're asking our organizations would cover your legal fees with other attorneys out there. If it is the second, the answer is no. We do not have such a thing in our mission or budget right now to pay you to have a consultation with another attorney out there who might file a case.
I think everyone Paris has already put in contact information for PARS. I think Rogine and Ali will also put in the contact information for their respective organizations. That was a request. Somebody has asked, it says, when I'm unable to finish my PhD in 1 year and the I-20 is valid for less than 1 year, and I have filed a 485 recently, can I extend the I-20, or is there a conflict? Go ahead.
Sure, I can jump really quickly. So that's a really good question, and you sort of nailed what the issue is. So F1 is what's called a strict non-immigrant visa classification, which means that when you entered or claim the F1 status, you have temporary intent to be here for the program. Once it's complete, whatever that is, you would be returning back to your home country. When you file for a green card on Form I-485, you're expressing immigrant intent. And you're able to do that, under, whatever the circumstances are. But once you've done that, going back and trying to extend or file something that is strict non-immigrant intent is deemed to be in conflict with your expression of immigrant intent. The thing is, when you do an I-20, it's a different agency than who you file your I-485 with. So your I-485 is with USCIS. Your I-20, as you know, is a CVIS record with ICE. The school might be able to put it in, but ICE can, that agency can determine, hey, this person has a pending I-485. They've expressed immigrant intent. So that would be an issue. I personally would not recommend doing that. I don't know if anyone else on the call has any, additional thoughts.
I agree. And also, as Rugine mentioned during her presentation, if you've already filed for an I-485, you're pending status, and you're allowed to remain while the application is pending. So I just want to make sure people understand that if the I-485 was filed while you were in status, then you're pending status, you're not out of status.
And then the other question that's posted here, it says, I've applied for my OPT at the end of October and will be graduating in about a week. Congratulations. Are you sure there's a pause on OPT?
Unfortunately, yes. So when you filed for OPT, you filed on Form I-765, even though you filed before any of these, changes happened, because it wasn't adjudicated before the changes took effect, the pause applies. So again, just to reiterate, you get to stay here. You don't need to leave, but unfortunately, until that pause is lifted, they're not going to adjudicate the I-765 application, and you do need to have the actual EAD in hand for you to begin work.
And to just emphasize what Regine said, the pause is on the decision on the case, but you could get fingerprinted, you can receive a request for evidence. We have all our appointments canceled, so all the interview appointments have been canceled, but all the fingerprints are going forward. We get biometrics every day for folks affected by the pause. Apparently we will be probably getting RFEs or notice of intents to deny, because that's what the policy memo clarifies, but the final decision has been paused. So yeah, as the president said, it has been permanently paused. I don't know how those two can work together, but there we are.
There is, and Regine had spoken earlier and advised everyone needed to who has their document to carry their documentation with them as to their status and all of that. And so I think that her advice on that is not only highly warranted and should be listened to, but this next question I think kind of relates to that a little bit, in the sense that this questioner has said, I have heard that with pending 485 and not having a valid parallel status, i.e. F1, H1B, et cetera, they can arrest you. So I guess I'm going to add a little bit to this, in the sense of I see both Paris and Regine nodding their heads yes. But what would be the advice that you might give along the lines of, Regine, what you were talking about earlier, and our advice in the sense of not only should you have all of your documentation or a copy of it with you, but possibly also memorized if you have access to the phone number of a lawyer that you can call, because if your phone gets taken in and during an arrest, then you don't have a phone number anymore that you may have programmed into your phone. So I'm going to add that you should memorize, if you have access to or know a lawyer who can help you, that lawyer's name and number, and then also your emergency contact as part of your preparation packet of sorts that Regine mentioned, and I have no doubt as part of the webinar that she posted. I know that is part of the advice that is generally given for these sort of situations. So I'm going to let anyone else who wants to chime in on that answer. One, if that is correct, the person's understanding. And then two, any additional advice. I think it's very important for people. This is part of the fear factor that's happening. Any additional advice that anyone would give to our attendees?
Yeah, I think the answer is yes and no. That the what's happening and what people are reading in the media are folks who are pending status, in this particular case, pending their adjustment. Maybe their underlying status has expired, but they're waiting for their adjustment of status, waiting for their green card application to be adjudicated. Now, what we have seen and heard is that folks who are in this situation and are being called for an interview, if their case is deficient, let's say something is not properly filed with their case, and the adjudicating officer determines on the day of the adjudication, on the day of the interview, that this case is not approvable based on what's on file, then they have the discretion to call ICE, step aside from their office, and let ICE in and take the person away. This is what's been happening on certain of these adjustment of status applications where the underlying, let's say, B2 visa, their visitor visa, or F1 visa had already expired and they were waiting for the green card. And that particular case had an issue, whether there was a criminal matter involved. Maybe the person had a criminal matter, or maybe there was something deficient in the filing of the application that was not approvable on the day. That's where we have seen ICE intervene and take the person into detention. Other than that, if the case is filed properly and it's adjudicated, and it doesn't happen like the person is walking on the street and ICE comes, it's at the time of adjudication, at the time of the interview. But right now, they're not interviewing folks for the final adjudication. So that feature is not there, really, like sort of like a double-edged sword. But it's not like people are walking, they're pending their adjustment of status application and ICE approaches them, unless, again, there's some criminal matter involved, some major issue in the case. And again, it could be also a national security issue. Maybe it's not a criminal matter. Maybe this person has done a military service at IRGC and they've somehow identified that and they're going to approach that person. That is a possibility. But in general, absent these other circumstances, there should be no issues with with the scenario that the person just mentioned.
And just to give another example really quickly, so if you didn't timely file your I-485, for example, so let's say you were out of status, we have seen stories of, persons who filed when they were out of status, and there's ways that that was excused. That is a scenario where you might have also seen in the media sort of amplified, especially at least on the West Coast in San Diego in the last month or two. That's also what you're probably seeing. So just honing in on what Paris said, there had to be sort of a deficiency or an issue for that to happen. With regard to best practices, I did post a bunch of resources. One of our resources aligns with exactly what Netta said, which is memorize the number of a trusted person or your attorney, have a copy of all your immigration documents somewhere and or give it to someone that's trusted, or have it somewhere where you know where it is so someone can get access to it. So one of the resources, the Know Your Rights documents that I included in one of those links, has a full overview of that as well that I would take a look at.
And then, so we have a next question that says, I have a chance to continue my education to DBA and keep my F1 for another 4 years. Do you recommend? I don't, Paris, you're nodding your head yes. So do you want to?
Yeah, why? I would say why
No,
not?
I think
I think we would all want more information as to like the cons of that question, because it seems like anyone who has the opportunity to extend and not have sort of negative repercussions or have to go through any sort of processing anymore would want to. So I think generally anybody on this call would want more information as to your specific case to know why one would not do that. Paris was nodding her head yes, and I think Roisin looks very excited to sort of jump in and answer.
I will just give one sort of my attorney answer when questions like this come up about continuing an education program. So this is a very official attorney answer. So long as you have the intent to pursue your education, and that's the reason why you are continuing your F1 program, then you pursue your educational career, your pathway. And I say that specifically, that the intent of you joining and extending your F1 should be with the intent of, completing an education program. If work is tangentially an opportunity through that, that's great. But the purpose should be that you're doing it because you intend to continue your educational studies.
I do, because it was mentioned, I'm going to skip very quickly to a bottom question, because we talked about dependence and marriage briefly, and there is a question on that. Somebody says, my F1 status is finishing this summer, and I plan to apply for H4 to be my wife's dependent. I believe I will be in a situation that my F1 status will be expired, I think is what you mean here, while my H4 application is pending. Would I be in legal trouble or deportation risk?
So long as you timely filed the change of status application, which means you file it before you've completed whatever your F1 program is, what before your OPT ends, for example, or if you're in your grace period, you're allowed to change status during your 60-day grace period. So long as it's received, not mailed, received by USCIS timely, then you are in what's called an authorized period of stay while that application is pending. So you're legally allowed to stay here, even if your F1 is finished and expires, so long as it's timely filed.
There's I guess, a kind of a question here, and I'm gonna sort of about having to go to Iran this summer for an emergency, and there's a delay. The F1 visa got expired, and now the student is stuck in Iran and they're on leave of absence. And is there anything to do? Um, that I will leave to Rogine and Paris. And what I will say is, because this person, Mojan, has then proceeded to say, can you help amplify my story or connect me with specific advocates? So I'm going to sort of talk on the front half. One of the things that PAAIA and all of the sort of organizations here really have found, I think, frustrating with the community is the refusal to share details. A number of years ago, there was bank accounts were being seized and frozen related to sanctions, and the fact that banks felt like they had to be particularly zealous when it came to sanctions and someone being or having anything related to Iran or last name identification. Wells Fargo was a particular bank that there was difficulty with. PAAIA sent to tens of thousands of people a request that if this has happened to you or somebody you know, please answer our survey and anonymously share your details. Because if there are not statements of fact, if there's not a case, then there's nothing that can be done. And so here, along the same lines, and I'm going to use Mojan's question about this, is UCAN 1, for instance, and Paris and I have talked about this extensively, particularly when it comes to what's happening right now, and that Iranians and Iranian Americans feel under pressure and are being squeezed from both sides, and different governments. This is a moment not to put your head in the sand, not to dig in and just say, I'm going to go to work and let me deal with my legal case. This is a moment to pick your head up and say, this is what's happening. So so at least on the PAAIA end, I know that a different non-Iranian community that Paris has worked with, the Afghans, they did actually, and they have provided details to media. And that human story is what's so important when we go and we try to make cases, because public narrative and public histories will have an impact in some courts. They will definitely have an impact on Congress. And so we need that information. We need to hear what's happening to you. And so unless you send an email that says, this is what happened to us in response, or just email it to info@paia.org, then we can't do anything. But part of what we think is a very important strategy is not only the legal cases to represent you, not only monitoring and getting in reporting requirements into legislation, but we think very much a media strategy that says, this is a community that has historically given to the United States, particularly in the STEM fields, and this is what's happening. And that media strategy can't work and won't get off the ground unless your very concrete moment is getting recorded. So I would, again, suggest you nicely, neatly, factually email info@paia.org so that when there are more instances of that, so I'm talking about the non-legal case, I'm talking about the media strategy, then we can talk to allies in the media about what's happening with data as well as your histories. So that's on my end. Rogine and Paris and Ali on the sort of legal end, when she says specific advocates, maybe you have something to add there.
I will just reiterate that right now, because it's just unfortunately a very different climate and different circumstance than the first administration where these lawsuits were happening. On the IABA side, and I probably can be confirmed by my co-panelists as well. In terms of advocacy, we are watching sort of how things are being implemented to be able to make the decision to make a step towards legal action. Right now, it's just not in a place where we're able to do that, and so otherwise, I think it would have been done in the last 7, 8 months. So we will announce that as an organization once it does come to fruition, something that's viable is done. But unfortunately, there isn't much that I can say that we can do in terms of lawsuits on these cases based on where we are right now.
There are two questions related to I-485. Is it permissible to file Form I-485 while my OPT application is still pending? Would doing so create any issues for my OPT approval or I-485?
So this goes back to the whole idea of non-immigrant intent versus immigrant intent. So if you have a pending application that's related to F1, which would be your OPT, that is related to your strict non-immigrant intent classification, which is F1. The moment that you do the I-485, not the I-140, but the I-485, you're explicitly expressing immigrant intent. So if that I-765 is still pending and they see in the system that you've expressed immigrant intent, then they can deny the I-765 on the basis that you've expressed immigrant intent and you're going through that pathway. It doesn't have anything to do with your status here in the States. That's a separate analysis. But with regard to the adjudication of the OPT, it would basically put it in a place where it's likely not viable anymore.
I don't quite I heard there's no need for USCIS approval for that. Not sure what that refers to. Is this true? So if you could
Well,
actually.
there was a previous question. I think Ali John had asked
OPT.
that he's gonna do DBA for 4 years, continuing this immigration status. I mean, the F1 status. So he's, I think, following up saying that he has heard that USCIS approval is not needed for that.
No,
This-
it's the OPT question and the DBA question.
That's why I was like, maybe you could clarify for us what that is. And then
Yeah,
we'll go to the next
he's
question.
applied for an OPT I-765 EAD based on his OPT, and he's asking whether that
Tyson,
requires.
he has continued again another
Oh,
question,
really?
2 questions down. He's
Oh,
talking about the DBA too.
oh yeah,
So, but
DBA.
why doesn't he clarify what he means exactly by it? Yeah.
And we'll move to another question, and then he can clarify very specifically what he's asking, and then we'll come back. So the next question is, if I apply for H-1B before the F1 expiration, is it acceptable? Does the receipt give me any benefits?
So the recommendation is if you have the opportunity to have the H-1B filed, please have it filed on your behalf. If you file it before your F1 expiration, so F1 expiration can mean several different things depending on where you are in your F1 program. If you're still in school and you have an H-1B filed on your behalf, all it means is once you stop your F1 program, you're in an authorized period of stay until the H-1B is adjudicated. Okay. If you are finishing your program, let's say this May or June, and you have an H-1B filed, you actually or let's not say graduation. Let's say you have your OPT is expiring this summer and you have an H-1B filed, and you have the H-1B filed before your OPT expires, you are afforded something called cap gap, which means that you get your OPT extended till September 30th. I think actually until your H-1B is approved now, you get to continue working. So if you have any questions on that, I don't want to get too much in the weeds, but depending on where you are in your F1 program, the only benefit that would basically impact an F1 is if your OPT is expiring and your H-1B is filed, you do get access to something called cap gap, which extends your work authorization automatically. It does require a new I-20 from your school, which isn't a USCIS benefit, so they should generate it. But if you have more questions, I'm happy to answer them directly.
Okay. And with that, it does, all right. My question is, to enroll for DBA, do I need USCIS approval? I already applied for OPT, and if there is no chance to get approval for OPT, I will apply for my DBA. Does the DBA need USCIS approval?
Database administrator, is that what DBA stands for?
I think it's Doctor of Business Administration. They're talking about the PhD level. Did your F1 expire, or you just hasn't?
I think my recollection is it hasn't expired, and he has the opportunity to do the DBA and not go through the expiration and just
Transfer the record. So it sounds like you would do a CVIS transfer to that program, which is, again, as I mentioned, CVIS is run by ICE. It's a different agency. There is no USCIS filing. So, and as Ali said, so long as you're in status and you're just doing a CVIS transfer, the USCIS doesn't come into play. So you don't have to worry about USCIS approval in that scenario.
Okay, I have a friend who has applied for STEM OPT, which is still pending, and the 180 days of automatic work authorization extension is about to finish. I understand that person can't work anymore beyond that, but what happens to their status if the pause is still in effect in another 6 months?
So they're legally allowed to be here, but they have to stop working on day 181. So again, this goes back to what it means, practically speaking, that that means there's no income, you're not working, and there's those, realities. But in terms of immigration status, so long as you've timely filed that STEM OPT, you get to work for those 180 days. On day 181, you have to stop working. You're legally allowed to be here in the US through that adjudication period.
I also just want to clarify for F1 students, there seems to be this belief that immigration attorneys can somehow change a lot in their outcome. The answer is really not the case. If they're waiting for an OPT, I mean, there's so much that an immigration attorney can do, or if they're losing a job offer. This is not a legal immigration matter, So I hate to say this, but a lot of people call and they're like, what Rusian is doing right now is this legal consultation. It's just telling them where they stand, what their options are, but actually applying for jobs or making sure that unless, let's say, somebody who practiced corporate immigration law like Rusian is doing the H-1B, but then the employer is Rusian's client, not the student. So I just want to make sure that's why immigration attorneys don't practice F1 visas, because there's no practice there.
Yeah. And just to clarify, when I say I work with students, it's really just to answer these questions. We don't actually do a lot of filings for students. Sometimes they want us help with an EAD application, or if there's like a litigation matter, like that's a very specific niche situation. But just to confirm what Paris said, there isn't really an F1 practice a lot. Most immigration firms or attorneys do. It's, we guide and answer questions like we have been today. We'll do the occasional EAD application just to make sure you've got everything in there and support that. But generally speaking, I see students when they have an employer that's petitioning on their behalf, and that's really when I meet them the first time.
All right. So I think we're at the 75-minute mark. I don't see any other additional questions. There. Let's see. One is that. I think, is it so risky to continue my F1 CVIS transfer to the university? Is it risky to proceed with transferring my F1 CVIS record to a day one CPT university that allows students to work on CPT while studying, while my employer is also planning to file an H-1B petition for me next month? I'm asking because I have not been able to find a viable academic program that can issue an I-20 before I fall out of status, and I want to make sure this strategy does not create immigration risks or negatively affect the H-1B filing, so called Day 1 CPT, which allows us to work on CPT while studying.
Great question. A constant issue. If we were under the first administration, they attacked day one CPT very harshly. We are not even 1 year into this administration, and this issue, I shouldn't even be vocalizing it and, you know, doing this, but they haven't challenged it yet. But the thing with day one CPT programs, and this is why I said, here's my official attorney answer about continuing your education. Your purpose for continuing education should be to, go to completing your program. If it offers day one CPT, that's great, but make sure that you do your research on your school, that it's accredited, the accreditations, that there aren't issues. But we have successfully been able to have people who go into day one CPT programs that are able to establish that they're pursuing their education. Where that comes in is in the adjudication of those change of status filings, especially for H-1B. Under the first administration, they'd say, hey, show that you actually were completing your program, working, properly in a work that is related to your program. That's where those questions came up. As of today, those challenges haven't really shown themselves yet. They kind of quieted down in the last few years. Just make sure you vet your school and that your purpose is education first. And if CPT and that internship class is there and you get to work during that, that's just an added benefit.
And then again, there's a list in the chat box of contact information as well as resources. I know that was a question that I just dismissed. So in relation to a previous question, in the situation where the allowed number of unemployment days is surpassed after the STEM OPT is approved, let's say after a year, would the student fall out of status?
It's a good question. I would love to hear what my co-panelists would say on this, but if you don't actually have work authorization, if you don't have an EAD in hand, then the unemployment days shouldn't be counting. If you have a valid EAD in your hand, then for post-completion OPT, it's 90 days. If you have your STEM OPT in hand, you get the additional days for a total of 150 days in those 3 years. But if you don't have that EAD in hand, then unemployment question should be moot because you don't even have the authorization to work.
That's right. The grace period applies when you're already work authorized.
Okay. Any other questions? No? All right. Well, I hope this hour and a half has been helpful, informative, somewhat calming, and collective in terms of what we can provide, both in terms of advocacy, planning, and then very specific questions that you have today that may help you address what is happening, and very much sort of the chaos and mayhem under which you're living. If you have, again, as I said in the chat box, there are significant resources from IABA. You can also find resources at PAAIA related to previous webinars that we've done on Know Your Rights. Some of the things I've said here and that like everyone has said here are also in some of those Know Your Rights webinars that happened July, August, September. If you want to specifically talk about your situation for a media strategy, please email info@paia.org. You have the contact information for our speakers. And again, I really hope that this has been, in some sense, both calming and very helpful in what is otherwise a very tense time. Thank you so much for joining us. Thank you to Ali, Rojin, and Paris a million times over. With that, we hope you do find it. I just somebody's insert in the box that you did very much find it helpful and informative. And with that, have a great rest of your day.